I'm Ben Meiselas from the MeidasTouch Network. A big ruling just handed down by federal judge Steve Jones rejecting Mark Meadows, the co-defendant in the RICO case filed by Fulton County District Attorney's attempt to remove the case from state court to federal court. Judge Jones just issued a remand order, meaning sending it back to state court, saying that federal court does not have jurisdiction. The federal court does not have jurisdiction over Mark Meadows' case. Mark Meadows did not even meet the minimal threshold showing needed for a removal of a federal officer to federal court. Mark Meadows now will almost certainly take an appeal to the 11th Circuit Court of Appeals, but this ruling follows a evidentiary hearing held before federal judge Steve Jones back on August 28th, where Mark Meadows made the unexpected and very damning and damaging decision to testify and to waive his Fifth Amendment rights. In an evidentiary hearing, evidence is needed. So Mark Meadows took the gamble that he could be incriminating himself while testifying, but that's how desperate Mark Meadows was. And indeed, Mark Meadows did incriminate himself, admitting that he likely violated the Hatch Act, that he didn't have really any knowledge about the outer limits of his job responsibilities, and also saying things that were discernibly false, like that he had no involvement at all with the fake electors. And then Fulton County District Attorney Fani Willis was like, here, the prosecutor who was there on our behalf said, well, here, this is the emails that show you are coordinating the fake elector scheme. And federal judge Steve Jones looked at the evidence, looked at the testimony in this 40-plus page ruling, and really said that Mark Meadows was not all that credible on a number of issues. That was important ultimately to rejecting the minimal threshold showing that Mark Meadows was trying to make here. But the most weight was given to the argument, a brilliant argument put forward by Fulton County District Attorney Fani Willis's team, that Mark Meadows was engaged in a constant violation of the Hatch Act, which precludes federal executive officials from engaging in political activity. And because Mark Meadows' conduct was involving himself in the political activity of a candidate of Donald Trump, even if we don't even talk about the RICO crime aspect of it yet, Meadows was engaged in conduct at the outset that he wasn't supposed to be doing as someone who works in the executive branch. It's strictly prohibited by federal law. So to claim that you should go to federal court while violating federal law is, of course, incongruous and without merit. But then you add that to the fact that the acts that Mark Meadows was engaged in included this RICO conspiracy to change the election from the winning candidate, Joe Biden, now President Joe Biden, to the losing candidate, Donald Trump. That is completely outside the bounds of any federal official authority. And that was the main persuasive argument for Judge Jones in this ruling. And so to be clear, Judge Jones denied Mark Meadows, remanded this back to state court. Meadows will almost certainly file an appeal to the 11th Circuit. So now not only did Mark Meadows lose his remand attempt, his decision to testify and then incriminate himself further and probably engage in perjury has now created a whole set of other problems. I could imagine a world where Fulton County District Attorney Fani Willis adds a charge for perjury against him right now for his false testimony, and the judge wasn't having it either. So here is the analysis given by the court. You'll see that it mirrors what I just said, but I think it's important that we dig into these documents. Really, here on page 9, it says, to determine whether Meadows is able to remove based on federal officer jurisdiction pursuant to 28 U.S.C. section 1442A1, the court must answer the following questions. That's part of the criminal criminal removal statute, which is 28 U.S.C. 1455, and then 1442 deals with these factors for removal of federal officers. The court must answer the following questions. 1, whether Meadows was a federal officer during the time of the allegations in the indictment. 2, whether the charged conduct in the criminal prosecutions were undertaken for or related to Meadows' color of office. And 3, whether Meadows has put forth a colorable federal defense for the criminal prosecution. And the state of Georgia, Fulton County District Attorney Fani Willis concedes that at the time of the events alleged in the indictment, Meadows was a federal officer. So now we move on to the next two elements. Was Meadows as a federal officer acting under the color of office of being a federal officer, and does he have credible federal defenses? And on factors 2 and factor 3, that's where Judge Jones says absolutely not, he doesn't. So then one of the things that Meadows was trying to argue is that these surrounding acts that he was engaged in, adjacent to what he is being actually charged with, the crimes, because he was like hanging out with Donald Trump and doing scheduling for Donald Trump and helping Donald Trump with phone calls. He says, look, that was in connection with my role as a federal official, so therefore I should get the benefit of the doubt, and we remove this to federal court. And what Judge Jones in his analysis says, no, if you actually look at the statute, the structure indicates that the criminal prosecution must arise from an act that is for or relating to the color of federal office. Even if a criminal defendant can characterize individual instances of behavior as part of his official duties without the broader charged conduct, this is not enough to convey subject matter jurisdiction on the court. Put differently, facts indicating that a criminal defendant at times operated under the scope of his federal office will not provide the court with subject matter jurisdiction under Section 1442 unless the state is criminally prosecuting the officer for the specific acts. So Fulton County District Attorney Fani Willis is not prosecuting Mark Meadows for scheduling things for Donald Trump or setting up phone calls for Donald Trump. When Meadows was engaged in inherently political activity, he was violating the Hatch Act and further engaged in a criminal RICO enterprise to overthrow the results of a free and fair election and change votes from Biden to Trump. That's not within his scope of being someone who's a federal official. And here's where it talks about Meadows testified. Now, going into the evidentiary record, Meadows testified that as White House Chief of Staff, he was bound by the Hatch Act and he could not engage in political activity. As discussed more fully below, the Hatch Act prohibits an employee from, quote, using official authority or influence for the purpose of affecting the results of an election. This includes using his or her official title while participating in political activity. And political activity is defined as, quote, activity directed toward the success or failure of a political party candidate for partisan political office or partisan political group. The court finds that the color of office of the White House Chief of Staff did not include working with or working for the Trump campaign, except for simply coordinating the president's schedule, traveling with the president to his campaign events, and redirecting communications to the campaign. Thus, consistent with his testimony and the federal statutes and regulations, engaging in political activities it exceeds the outer limits of the office of the White House Chief of Staff. And then the court says the court gives less weight to Mark Meadows' assertions that all his actions he took were within the scope of his office. When questioned about the scope of his authority, Meadows was unable to explain the limits of his authority other than his ability to stump for the president or work on behalf of the campaign. This is citing Meadows' testimony. The court finds that Meadows did not adequately convey the outer limits of his authority, and thus the court gives that testimony less weight. And then the court says that Meadows did not even meet the minimal threshold showings here, and that he has not met his burden for establishing that the acts at issue are related to his office. The court concludes Meadows has not met even the quite low threshold for removal. There you have it, folks. Big ruling by Steve Jones. Meadows will almost certainly appeal. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers. Have a great day. Check us out also at patreon.com/MeidasTouch.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.